suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
And David Whiting is here, your talkback lawyer, answering your questions. Good morning, David.
Good morning, Raph.
You had some homework?
I did. Tony from Elstonwick. Tony rides a motorbike. He likes to ride up Punt Road and Hoddle Street and turns left into Victoria Parade. But he finds that the signs are different, and there is in Punt Road or Hoddle Street on a bus lane a sign that shows a bus and something that Tony until today thought was a motorcycle.
I thought it was a motorcycle. I can picture that sign. I wish I could picture where, but I know that sign.
And when you turn left into Victoria Parade, there is a bus sign that has a bus on it but no cycle. So, and then you need to recognise that there are bus lanes and there are bus-only lanes. All right. In a bus lane, you need to be a public bus or a coach, and a coach is something that's rented out for people to use to carry passengers, and is 9.5 metres long, 30 feet in the old language, or a bicycle or an electrical scooter. Motorbikes do not have the right to travel along in a bike lane. All right. Now, and in bus-only lanes, it's just buses.
No buses, no motorbikes.
Buses, yeah. So, sorry, Tony.
Done.
You probably need to get your eyes checked rather than anything else. But, yes, it is not a motorbike. It is a bicycle.
I am going to keep my eye out for that sign and know that sign. I pass it all the time. Ron is first up, calling from East Malvern. Ron, what's your question?
Good morning, David and Raph. I have a legal quandary. In 2001, a magistrate at the family court made a decision which one of the orders was that our jointly owned house was transferred to her. We had both assumed that had happened. In March this year, I got a letter from the State Revenue Office wanting me to pay $975 land tax because it's a second property that I own.
Yes.
Now, I've written to the Revenue Office seeking that there might, in the circumstances, I haven't lived in the house since 1997. I was hoping that they would have the power to waive that.
They do have the power, Ron. Whether they'll exercise it is another thing. But I suggest that you get it done between now and the 31st of December because you'll get another land tax bill in February.
Mm-hmm.
So, Ron, what happens is that they register owners. The fact that your ex-wife is the beneficial owner of the property isn't the test. It's registered owners. Now, there are some exceptions. Yours doesn't count. And the decision that was handed down in the family court 20 years ago was a direction, more or less, that you transfer your interest in the property. Now, because the Registrar of Titles wasn't a party to the transaction, it didn't happen. So you've now got 45 days to fix the problem.
Well, the title has been fixed. We've both been cooperating with a legal firm, and that I am now removed from the title.
Oh, well, you've got to pay the $950, but you won't get another one.
So you think I still have to pay the $975?
You have an obligation as the owner. Yes, you do.
Okay. Thank you.
Thanks very much.
Ron.
Bye.
Good luck. Rose is in Whittlesea. Rose, what's your question?
Yeah, hi. I just got a sort of a question. About 12 months ago, my son's girlfriend had to get out of her rental house. Couldn't find a place, so my husband and I let her come and live with us. She pays like $100 a week for the board towards food and whatever bills. Yep. There were sort of a few rules I made, sort of, I don't want I don't want any drugs in the house and this and that. I've got minors in the house. I've found stuff.
What do you want to do, Rose?
I wanted to get out.
Well, that's okay.
There's other issues as well. and we've all got grief, but that she has quite substantial mental health issues that I didn't know about.
You're not required to have her in the house. It's not a residential tenancy. It's not caught by the rooming house legislation. You are entitled to bring it to an end on whatever notice period you think is appropriate.
Okay,
Now, that might be 5 minutes, that might be 3 weeks, that might be whatever.
Yeah, okay. Because all right. Because I wasn't sure because she actually physically pays me whether I was a landlord.
No, you're not. It's not a residential tenancy the way you've described it, so it's not caught by that legislation. It's not a rooming house, which is the same legislation.
So it's Rose's house.
So it's Rose's house. The answer would be she is, let's call her a tenant at will. Yep. And that's your will, not her will. So yes, you can terminate the arrangement whenever you like, and you can evict her. Yep. And the Landlord and Tenant Act is a weird piece of legislation, and in the circumstances you have described, you can exercise self-help, provided that it's not going to lead to a breach of the peace. All right? Mm-hmm. So you might like to go off and get some advice. You might wander down to the police station and tell them that that's what you're going to do, and you might pack her stuff up and put it outside.
Yeah,
but be really careful, Rose.
Yep. Stuff.
And your son is going to need to be there to make sure that things don't get out of hand.
Yes.
In fact, they might both go, Rose. You might have more room in the house.
I said yes, but it'd be Can I say that on the
Well, you did, but because I know you really don't live in Whittlesea, so we're fine. All right?
Okay. Good luck, Rose.
Thank you, Rose.
Thank you.
Good luck. You've got all power to you, and you've got the legal power to do that. Leslie is calling from Rosanna. Leslie, what's your question?
Oh, hi, David. Hi, Raph. What are the legal remedies to get a neighbour to clear a fire hazard that's near our common boundary? It's a carport with furniture and what looks to be other flammable things. We've asked a couple of times, but no action, and we're quite keen to stay on good terms.
Leslie, what renders a lounge suite flammable? I mean, there's a whole lot of things that exist around your property that would burn if the fire was applied to them, but it's very unlikely to be some spontaneous combustion. If you find that the guy next door's got grass that's dry and tinder-like and is 3 foot high, then you can get the council to issue a fire hazard notice, and then the council will require that the work be done to their satisfaction, or they'll come in and do it and charge the landowner. But the fact that someone's got furniture stored in their carport, I don't think council will give you the permit, or will direct them to do that clearing.
Okay, great. Thanks.
Okay.
Start. Thanks, Leslie.
Good luck, Leslie. Michael is calling from Collingwood. What's your issue, Michael?
Hi, David and Raph. Look, I'm a tenant in public housing, and I raised a safety issue quite politely, and the manager of the site come back to me with, simple, mate, we're going to relocate you as a threat. Now, I just wondered, what's my next best move, as in, like, I don't know if you need to maybe think about it for homework, David, but who can I go to challenge what they've said to me and the threat that was made?
Well, I don't know that I could, on the limited that you've given us, I would describe it as a threat. You've told them that there is an issue with the property, and they may, if I was them, and I'm not them, I would argue that the way I can solve Michael's problem is to move Michael.
Okay, so just to expand on it, the error they've made is they've altered the common area, and it's affecting all the tenants, that now people with walking frames and wheelchairs can't navigate the system. So they've made this really quick decision to try and fix one thing, but haven't considered the implications to all the other tenants.
Yeah, thanks for that, Michael. I'll take it as homework. See what who or what is next up the tree to make your concerns be assessed in a different way.
Yeah.
But if I was them, I would come along and say, you've identified a problem, Michael. The way I can make the problem go away for you is to make you go away. That is to relocate you, not throw you out, but relocate you.
Yeah, I think they're doing it as a simple threat that sort of covers themselves.
Well, a simple solution. I'm not prepared on what you've said to call it a threat. But next week, Michael.
Okay, we'll take that
Just
as
keep
homework.
your head down till then. All right.
Thank you. Bye.
Right.
Thank you. Kate is calling from Bendigo. It's 17 minutes past 10 with a legal talkback question for David Whiting. Kate, what is it?
Oh, yeah, good morning, David. Good morning, Raph. Yeah, I'm calling with a probate question. So my mum died in late April this year.
I'm sorry.
Yeah, thank you. She had a diagnosis of dementia, and she apparently made some fairly minor changes to her will after her diagnosis of dementia. I haven't been able to get any kind of clear idea of when...
You've got a copy of the will, haven't you, Kate?
Yes, I have.
Right. Now, there are two places where you can look there, but they changed on Monday, so I'm not entirely sure we'll get there. supremecourt.vic.gov.au.
Yep.
You go on the Wills and Probate tab.
Yeah.
And what you're doing is you're searching for advertisements. Now, the first thing...
What's it called?
Advertisements, because what you're looking for is, has anybody made an application for a grant of probate of your mother's will? And if so, that will tell you who and when, right? Now, if you don't find anything, that's not as if you can't find ads, but you just can't find the right one, then nothing appears to have happened in a practical sense. In the event that you find that the application was lodged, that the advertisement was placed, you then do what's called an application search.
Right.
And you can put in your mother's full name and it will tell you if a grant of probate has been made and if so, when. So the ad will tell you who made the application. The application search will tell you when probate was granted to them.
Okay. When you say that who made the application, are you talking about the solicitor or are you talking...
The executive.
Yeah.
Yes.
Yeah. Okay. All right. Good.
That will get you further along. You know who the executors are?
I'm one of them, and I do know who
the other ones are. But they won't have made an application without you, will they, Kate?
No, we're just waiting on probate to come through, though. So
no. The answer is this is just taking far too long. So there might be an issue, but that will tell you, the application index will tell you if an application has been made, so you know whether the issue is at the court level or prior to the court level.
All right.
All right?
Good. Okay.
Thank you,
Thank
Kate.
you very much.
Good luck, Kate. And Bethany is calling from Nunawading. Bethany, what's your question?
David, I'm hoping that you can help settle an argument between me and my husband. We have two children in primary school, and I am keen for them to start walking home from school. And he said, no, they can't. There's a legal age at which they're allowed to be left alone. And I'm like, where is it? So, David, I'm wondering, what does the law say in Victoria about kids walking home from school? Is there an age limit?
Nothing. It doesn't say anything. So it's really it's the age at which you and your husband can reach agreement. All right now, and there is no age. It's an assessment by you of the maturity.
Oh, so I thought you meant the age at which we had to be before we.
I hope you're already there, Bethany. But
we're assuming you're over 18.
Yeah. I hope so.
Yes. So it's you strike it, and it might be different for different children. I mean, we don't all mature at the same age, at the same rate, anything. So that's where I would be suggesting is that's the discussion. Why not have a discussion with a class teacher and see what proportion of the kids in the class now walk home on their own? It might be a little bit further than that, though, Bethany. It's not the school to your home, it's them being left on their own at home. Now, there are lots of kids, latchkey kids, who let themselves into their house and look after themselves until mum or dad or both get home. It's really up to the two of you, but get some feedback from the school as to what's usual for your kids and their age. And if there's an observation by those class teacher as to their level of maturity, I think that would be a real positive.
Amazing. Thank you. I really appreciate it.
Good luck, Bethany. But there must be
That's
an illegal...
not being a lawyer, really, yep.
I can't leave a 6-month-old at home alone. Is that against the law?
Not in those words, but the question is, are you adequately looking after the child?
Is it neglect?
Yeah, it's a neglect question.
Yeah, right. So there's not an age limit question. Is there something?
It's a neglect question. I mean, it's kind of like we'll use the... I don't know. Well, I was going to say, is there a law about leaving a child in a car? The answer to that question is, I don't know. But that's a whole series of different circumstances.
Yeah.
Yeah?
How old were you when you first started travelling? Like, what grade were you in?
I lived across the road from the school.
Ah, that's cheating.
It wasn't a big issue for me.
That doesn't count. Okay, that doesn't count. I started grade 4.
I started grade 5 catching the bus to a different school, but but prior to that, I lived across the road.
Okay, there you go.
But
that's interesting. There's no age limit. It's about neglect.
It's a neglect question, yeah.
Right. Interesting. 1300 222 774 is the phone number if you have a legal question for David Whiting, a childminding question for David Whiting. Give us a call. And we've got a question from Kaz, who is calling from Geelong. Go for it, Kaz.
Oh, good morning, gentlemen and listeners. I've got a question about state trustees. My mother's affairs are being worked out with state trustees.
So state trustees are your parents' administrators, is that right?
Yes, I only have one parent left who's elderly and has dementia and is in care, and I am the executor of her will. So when she passes, how long does it take state trustees to transfer her affairs to me?
Well, what they will do is they will finish the administration and provide you with a report. You make an application for a grant of probate, and when probate is granted and you provide them with a copy, it shouldn't take them more than a week or two to transfer the assets to you.
Okay.
All right.
All right. Yep.
So I've got the interesting one in reverse. I'm an administrator for a person where I know state trustees are going to run the estate. And so my question, I've gone to VCAT and got permission to pre-purchase a gravesite, prepay a funeral, do those sorts of things. And the question really then is, at what stage, what do I just ring state trustees and say, X has died, give me a call? I don't know. Anyway, sorry. So Kaz, that's so I would suggest you go to state trustees and tell them that your parent has died, because you'll know before they do, and you then they will provide you with information, and you apply for a grant, and then they will hand the assets over. But it might even be a really small estate, and a grant is not required. I don't know.
No, well, it'll be over $1 million.
Then a grant will be provided, and they will require you to get a grant of probate before giving you anything other than information.
Yep, all right. And while my mother's been in care and state trustees have been running her affairs, I've been purchasing items for her, and I was unaware of limitations with that, and originally I was told that to send the invoices back to state trustees, and then someone else took over her case, and they said I've got to get prior approval to purchase things for her, and I'd already bought a lot of clothes because she put on weight, and it's just been too difficult to claim the expenses. But as the executor, can I claim those expenses?
Well, technically not claim them, but you could reimburse yourself for the monies that you'd spent while your mum was alive. But but then there's the reasonable and proper test that would need to be considered. So, so as a principle, yes, you could reimburse yourself for those items.
Okay. Good, because it's just been too difficult, So, and can I get a copy from my mother's lawyer of her current will?
No.
Okay, Good, thank you.
Okay.
There you go. Good luck, Kaz. Answering lots of questions this morning, David Whiting.
Talking fast.
Don't know what's going on. Guy is in Northcote. Guy, what's your question?
Hi, David and Raph. Thanks for taking my call. So I had a ducted aircon repaired by an installer company in December last year for around $6,000. 6 months later, the aircon broke again, same bits and same parts, so they have to be replaced again. The manufacturer has agreed to replace the parts, but the installer wants to charge for labour as well.
Yes.
And will be another $2,500, $3,000.
Wow.
When I did a search on the ACCC, it says there's something under the repair, replace, refund, cancel, say that the labour should be included and that the company installer should seek reimbursement from the manufacturer.
I don't know any more than you've told me about what the fault was, but as a general principle, the replacement of a part should include its installation. Yes.
Yep.
Though you might go to VCAT
Yep.
and wait a couple of years for your answer. It's just a delay. But as a matter of principle, yes, the replacement. So I'd be going back to the manufacturer and say, if you're replacing it, why aren't you paying for it to be put in?
Yeah, so it's another company that's selling their product. You know what I mean? That aircon.
So have you got two contracts? Have you? Have you got a contract
No,
to
I've got
buy
one
the
with
part?
the company that has repaired it, but that's not the manufacturer.
I know because most of the manufacturers are overseas, so you're stuck with that anyway. I would go back to them and say, you supplied a part which is proved to be faulty. I expect you to replace it, and for the labour cost to be paid by the manufacturer.
Yeah, and the company should seek that from the manufacturer.
You should come along and say, I don't care.
Yeah.
From your point of view, you installed something, it's not working, I want you to fix it.
Yep. And the next step is to go to VCAT, is it?
Yes. One of the things you would look at is see whether there's a guarantee or a warranty on any of these things.
Yep.
So you might look and see, is there a 12-month replacement guarantee? Is there something like that? That might... and then it's the question is whether the guarantee is reasonable, A 90 minutes or 9 kilometre warranty is probably not really good on a car. So the question really is there a warranty with these parts? And really, how old is the aircon system, Guy?
Well, it was installed 10 plus years ago, but all the parts, like the compressor and the board, have failed, which was exactly what they replaced last December.
Yeah,
So
and they would have, in theory, they would have put something in new. So I would be having a look and seeing, So I would be stuck with a person that you are getting to repair it and just simply say, as far as you're concerned, the part and the labour are your problem.
Yep.
Okay.
Great.
Thanks, Guy.
for confirming. Cheers.
Good luck. So you got a little bit of homework there, David, on public housing.
Public housing and safety versus relocation.
Oh, indeed.
Thank
you, David. David Whiting here every Tuesday answering your legal questions.